years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So, all right, you are Ebony Broussard?
Correct.
And this is cause numbers 19-32518, 19-32806, and 21-36615. Ms. Broussard is on probation in the 32518 and 32806, was put on probation January 21st of 2020. 10-year deferred probations. One was escape while arrested, and the other was the second-degree assault on a peace officer, and then was placed on probation July 12th of 2021 in the clause number 21-36615 for a 5-year deferred probation for a state jail felony offense of possession of a controlled substance. She was here previously, entered pleas of true to counts 1 through 5 in that motion to revoke in each of the cases.
No, Your Honor, everything that we have in there is very direct in support.
All right, thank you.
And my only position, Judge, would be that she's obviously been extended almost every opportunity that probation has, every class, every structure, every program, and it would not be the position of the state like it typically is to argue for safety. In fact, I would argue strongly against it.
All right, Mr. Kimler?
I suppose, Your Honor, in response to that, she has demonstrated an ability to complete the programs, which is reflected in the pre-sentence report that she has been ordered to attend. Of course, there is a pattern of conduct that reflects addiction and substance abuse, but she also has the ability to complete the programs as well. I don't know how that relates to her inability, I suppose, to cope with the substance abuse issues, but she does have the ability at least to have enough structure and conform with the structure of these programs to complete them, so that says something. It looks from the pre-sentence report, it would be asking a lot to continue her on probation, especially with probation probably being unwilling to, or at least reticent to do that. I would only ask the court, if the court is considering the revoker, to consider something at the lower end. She does have children, and I'm not trying to use that as an excuse or anything, but they could maybe perhaps...
Children she was on her way to get while she was under the influence of PCP?
I don't know that they established conclusively that she was under the influence. I mean, again, it reflects the substance abuse problem, but she does...
played true to all of the counts.
Right. But yeah, that's true, Your Honor, and it reflects a continued struggle with substance abuse.
Yeah.
And so the issue then is going to be probably incarceration, but I would just ask that it be something not extreme, but at the upper end. And she wanted to address the court. What do you have to say?
I do take accountability for my actions, but however, I have completed ISL before, and if you would be willing to work with me again, I would appreciate it. I have, before I was incarcerated, I did enroll myself in outpatient classes, which was referred to me through Ozark when I got assessed, and I was taking AA classes as well. I did complete 5 of the classes, however, I wasn't able to complete it because I was incarcerated. I do still have my job, and I did complete my 5-year probation for the first conviction. And I do pay my...
So is the time... It was told, I mean, because of the motion. So yeah, I mean, you did the 5 years, but yes, it's not over.
Yes, ma'am.
So, Ms. Broussard, you've been given the opportunity of, looks like you went to Franklin North way back in 2017. And then you get on probation. You went through JCDI, but you couldn't complete it because of progressive sanctions for continuing to not follow those rules. Then you went to Franklin North, December 7th of 2020. You were on the drug patch program. You did that. You went to anger management. You went through the moral recognition therapy. You were on the high medium caseload. You've been to ISF. And despite all of that, you're still on 2 probations, one of which you could get 20 years in prison and the other 10. You still haven't figured out how to stop using drugs, and you were in fact in a vehicle going to pick up your young children from daycare under the influence of PCP.
Oh, man. However, when I went to Franklin North, it was because I was in a toxic relationship. And that's what they did.
But here's, okay, how
And
how old are you?
I'm 42, man.
Okay, so you've been through what appears to be years of drug addiction. And at 42 years old, and you've been on these probations for 5 years or more, you've had every opportunity handed to you to try to help you, and you're still using. So at this time, in clause number 19-32518, I'm going to find counts 1 through 5 true, find sufficient evidence to find you guilty. And at this time, find you guilty of escape while arrested, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And clause number 19-32806, find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for the time that you've been in custody, but the law gives you the right to receive. And then in clause number 21-36615, also find counts 1 through 5 true, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All of these sentences will run concurrently, which means together at the same time. I'm going to hand you the trial court certification that shows there was no agreement. You do have some rights to appeal. You need to sign that with your attorney, and then I'll give you that copy. Also, I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law. It's saying that you do have a right to appeal, and Mr. Kimler will talk to you about that. You hand her that one, and just the bottom copy off of that one, Mr. Kimler.
When can I find this great time?
They'll do the judgments today, and it should show up in the computer probably in the next day or two.
Mr. Jill does not give us this information.
It's, well, right now it hasn't been all calculated, so it'll be in the system in the next day or two. Once the clerk, she's in court right now, so she can't do it, but it'll happen the next day or two.
This hearing wasn't about a single mistake, it was about years of missed opportunities. Judge West carefully reviewed the defendant's history of treatment programs, probation, counseling, and repeated chances before reaching her decision. The sentence reflected the court's conclusion that rehabilitation had been offered many times, but the cycle of substance abuse and probation violations continued. In the judge's view, accountability had finally reached the point where incarceration became necessary.
Right, sir, you're Asa Jones, and this is cause number 25, DCCR 0963. Mr. Jones is charged with a first-degree felony offense of aggravated assault, and the case is set for trial to begin with jury selection next Monday. What is the announcement?
You should be ready to state your ready.
All right, it is likely going to be at the top of the list. I have one other that's potential, but it sounds like there might be some issues, so, but you'll know today after docket. I do want to make sure you understand, Mr. Jones, that after today, I will not accept any plea agreements. It looks like I've got a plea bargain rejection from January of this year where you rejected a 25-year term. Has there been any change in negotiations?
No, Judge. Yeah, we have a witness that would ask the court call the name of, please.
Okay.
Atlanta Gallo.
Atlanta Gallo, please.
We asked that the court admonish her, she's under subpoena, admonish her about the consequences of not showing up for the trial next week.
If you'll just have her come over here on this side. Good morning, ma'am. And your name's Atlanta Gallo?
Yes, ma'am.
And Ms. Gallo, we're here in clause number 25, DCCR 0963, and Mr. Jones' case is set for trial for next week to begin on Monday. You are placed under subpoena for that, and I just want to make sure you understand that it is required by law that you show up whether you want to or not for court next week. At whatever time the district attorney tells you and whatever time that subpoena told you, you have to be here. If you don't come, now that you've been given this order and that subpoena, there could be some consequences where you would get in trouble. Do you understand?
Yes, ma'am.
You could be held in contempt of court. There would be a fine. You could potentially go to jail yourself for not showing up. Do you understand?
As this hearing came to a close, the focus shifted from sentencing to trial preparation. Judge West reminded everyone that once jury selection begins, plea negotiations may no longer be available. She also personally warned a subpoenaed witness that ignoring a court order to appear could lead to contempt proceedings, fines, or even jail. It was a clear reminder that courtroom responsibilities apply not only to defendants, but to witnesses as well.